Welcome back to our Legal Talks. Today we are going to discuss very important Kerala High Court judgment. Can a father serving a life sentence be granted parole, not for medical emergency or funeral emergency, but to help his son begin his higher education journey? This video we explore a touching and progressive ruling by Kerala High Court, which reminds us that behind every convict is a family and behind every sentence is a story. Let's understand how the court balanced the scales of justice, parental responsibility, and compassion. See the background of the case. The writ petition was filed by a woman, wife of a man undergoing a life imprisonment at the central prison. Her son had just cleared his 10th standard, was excellent, brilliant student with excellent grades and was seeking admission to plus two course, that is intermediate. So the request was 1 week parole for the father to assist with admission, fee arrangements, and emotional support. The prison authorities rejected the request, stating no such parole prison exists under the prison rules for this purpose. But mother didn't stop. She moved the Kerala High Court under Article 226. Court's initial response, the matter was heard by Justice P.V. Kunhikrishnan and the Honorable Justice, known for human approach to jurisprudence. The court asked a simple but powerful question. Where the mark list of the chain? Might be a simple but powerful question. He asked the mark list of the chain. On producing the mark sheet, it showed 6 A+ grades, 2 A grades, a brilliant student with only one humble request. Let me start my next academic journey with my father by my side. So, legal analysis and judgment. The court acknowledged convicts do lose some rights while in a prison, but they do not lose their basic human rights. And more importantly, their children do not lose the right to parental care and supports. Honorable Justice observed a father's role is not just about authority, it is about guidance, emotional support, and mentorship. The court held that education is a constitutional right. Supporting one's child during a key educational transition is a part of a father's fundamental dignity. The court's directions, the court allowed emergency parole for 1 week from 12th June 2025 to 18th June 2025 with conditions. The convict must execute a bond of 1 lakh rupee, furnish 2 solvent securities, must report back to jail by 4 p.m. on 18th June 2025 without fail. The parole was not unconditional, but it was measured and compassionate. So, what makes the judgment special? These judgments stands out for several reasons. It shifts the lens from punishment to family impact. It reaffirms that a father's presence, especially in a child's education, is not option. It is a vital. It reminds us that Article 21, right to life and dignity, applies inside prison walls too. A social message, dignity beyond prison. Imagine this, a child walks into the college admission office not with money or influence, but with his father, who has been granted 7 days of freedom. That child knows that his dreams matter even to a court of law. These judgments send a message to prison authorities. Show discretion with humanity. Families of convicts, your right did not end with a conviction. The legal community, law can be both just and kind. So the practical takeaways. Emergency parole can be sought even for personal family reasons if backed by fundamental rights. Courts are open to compassionate petitions. Don't hesitate to seek relief. Strict rule books should not blind authorities to legitimate humanitarian needs. This is the message is given. Conclusion. This is not just a story of father and son, of how law can reach into the shadows of prison and light a path of hope. If this video moved you, if you believe that justice must always carry a heart, like, share, and subscribe. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe for more updates. Thank you.